I'm John Child. I'm at the University of Birmingham, and I'm one of the co-directors of this network with Jonathan. The network, as was also mentioned, is a network of both academics and practitioners and other experts in relation to criminal law generally. And the idea of the network is one of collaboration towards various reform projects that we identify through consultation and then work on as a collective group to bring through various stages of research through to publication of reports. Four major projects that we've been working on. So we started in 2017. Our first major project was on computer misuse. That reported in 2020. And actually, partly as a result of that report, we now see the Home Office launching a consultation just in May of this year, looking directly at potential reform of the Computer Misuse Act, which obviously we're engaged with now at the moment. Our second major project is on private prosecutions. That's actually being led by Jonathan, and that one is nearing completion at this point, and we're on target at the moment to publish the report and launch the report on that in January of 2022, so just around the corner really. Our third major project, more recently begun, is on deception and sexual consent. On that one, we've taken a slightly different approach, whereby we've basically identified a number of authors who are writing chapters for us, looking at different approaches to the problems of dealing with understanding deception and non-consent in sexual relations. And that's coming to a head. So that consultation based on those various chapters will be coming together in the next few months, and we'll be launching that as a consultation exercise in November with the final report later on in the year. And then the last project, which has already been identified, is on the regulation of drugs. So obviously one of our topics today is also on this topic, so we'll be looking at that closely. And that's one that it's still in formation. So the project itself is going to launch in the spring of next year. And the first event on that, again, all of these events are ones we would encourage, if people are interested, to come along to and be involved in. And that first event is always then about sculpting exactly how that project should be put together, where we can offer the most benefit to existing literature and existing kind of reform materials. So all of those things going on at the moment. Please do get involved. The whole nature of the network is meant to be collaborative. Follow our progress, get involved via our website, join our mailing list via our website, which is just clrnn.co.uk, and indeed follow us on Twitter. We also have a relatively new blog on the website, and we're always keen. It's a good way of sort of introducing us to new people. Please blog on anything that we're working on in terms of our projects, but also more generally in terms of reform issues across the criminal law. We're always keen to look for new authors for that, so please do just get in touch if you have something interesting to share. Having said all that, though, today's event is not about one of those sort of major projects, but rather it's a showcase, if you like, of exciting sort of reform ideas in the criminal law. And so we're really excited to hear. We've got 10 speakers, 10 proposals, if you like, today that we're going to go through, each with these short talk format. The event itself is funded by the SLS. We have Rob on hand, who's also looking after the technical side, which is excellent, which is obviously necessary through the funding. And the event is in association, as I mentioned, with the criminal law team for the Law Commission. And Professor Lewis will talk about that in a moment as I hand over to her. And all of the proposals from this event are feeding into the Law Commission's consultation on law reform for their 14th programme. We had a similar event to this, as I mentioned briefly, in 2016, and actually that was the event, similar format, which led to the formation of our network in the first place. So we're excited to be sort of as an anniversary, if you like, a bit for us in terms of the next one that's come around, having started everything from the previous one. And it's always a really good event for sort of getting new ideas and thinking big in terms of potential for law reform projects. That resulted in an edited collection that came out with Heart a couple of years later, and indeed that's the same format, as Jonathan mentioned, that we'll be looking to do this time. So again, look out for the book down the road from this event if you find the talks interesting. I'd also like to briefly plug a little sister event. So just as we were brand new, in 2016. So there's a new group called Family Law Reform now, who are brand new this year, and this will be their first event. And their equivalent of this will be taking place on the 13th of September. So if you're interested, please do also log in and watch their talks. They've got a really exciting range of people speaking. Pinning down a bit more to today's format. So as I mentioned, we have 10 proposal talks, basically answering this question writ large of where in the criminal law, if you could change something in the criminal law, what would it be? And we've got a range of really exciting talks to bring to you. All of these, as you know, if you're watching on YouTube now, are being streamed live onto YouTube, onto our channel on there. The recordings will also be made available after the event. It will probably take a week or so just to tidy things up, but those will then be available on YouTube for you to be able to watch afterwards and refer other people to if you found them interesting. Whilst you're watching, I've got a second screen to my side there. Whilst you're watching this, please do get involved in terms of asking questions or making comments. The way to do that is if you click on the live chat function on YouTube, you can just make comments about the papers as they're being presented. You can ask questions of the speakers. And what's going to happen is at the end of each of the talks will last approximately 15 minutes. As long as there is time at the end, which hopefully there will be for all of them, I will tune back in to take 1 or 2 questions from that chat on YouTube to ask the speakers directly live today as well. So please do get involved in that. Any comments you make or questions that obviously we don't have time to deal with now, those will still get passed on to the speakers afterwards anyway, so you can still sort of help them out in terms of your comments that you might want to draw. Obviously, friendly, please. And yeah, so both in terms of that and of course a bit of interaction where I can relay a couple of the questions after each talk as well. Okay, on that note, I'll pass back to Jonathan. Thank you. Jonathan, you just need to unmute.
Hello, I've just unmuted myself. I'm going to be doing this a lot today, and I apologize in advance for all predictable aggravation and frustration. As I was saying a moment ago when I was muted, it gives me great pleasure to introduce Professor Penny Lewis. Penny has been at King's College London for over 20 years and was made a professor there in 2007. I first met her in 2011 in conjunction with a workshop organised at KCL concerning euthanasia and assisted suicide. Today, Professor Lewis is the Criminal Law Commissioner of England and Wales, and I rather suspect that the one subject which could never come the Law Commission's way must be that of euthanasia. But with that rather irrelevant point, I shall now hand over to Penny to tell you what she will be working on instead.
Thanks, Jonathan, and thanks, John, too. I'll just briefly outline sort of who we are and what we do at the Law Commission. I'm sure many of you already know the Law Commission as a body, but I thought it might be useful, given that we have a sort of widespread of experience in the audience, to briefly outline the sort of scope of our work, particularly in the criminal law sphere. So the Law Commission is an independent body with a statutory responsibility to keep the law of England and Wales under review. As you might imagine, that's a pretty challenging task. So the way we do that is we take on projects and carry out public consultation areas of law to work out how well the current law functions and recommend reform of the law where needed to make sure that it is fair, modern, simple, and cost effective. So to do this, as I mentioned, we take on projects. Projects typically run for between 18 months to 2 or even 3 years. And the aim of a project is to make recommendations for reform of the law. For the most part, occasionally we take on a more scoping type of project. We currently have one of those on the go. And sometimes a scoping project will lead to a formal project where we will make recommendations, and sometimes it will not. In those circumstances, the government might decide to take forward further work themselves, or they might indeed decide not to make any changes to the law in that area. So the key question I suppose that then remains is, how do we choose our projects? If we're not able to keep the whole of the law under review, how do we select? And decisions about whether to take on a project are based on the strength of the need for law reform. So sort of colloquially, like how much of a mess is the law in a particular area, the importance of the issues and the potential benefits which could flow from law reform, the availability of resources in terms of both expertise and funding, and whether the project is suitable to be dealt with by the Commission, which is an independent body which is non-political. Since 2010, we have had a protocol that was agreed with government under the 2009 Act, which reformed our statutory functions. And that protocol provides that there must be a serious intention to take forward law reform by the department with relevant policy responsibility. And the reason for that is really that we are a body with very limited resources. We're quite small, and we have agreed not to sort of spend those resources on projects which have no hope of implementation. That doesn't mean that a government department is committed to implementing recommendations, although obviously we're very pleased when they choose to do so, but there must at least be a serious intention to do something about the law in that area before we will take on a project. So as you can imagine, that means that we have to liaise very closely with government departments, and we are not making decisions about what projects to take on. What projects to take on in a vacuum. We are doing that in consultation with relevant government departments. Projects are agreed in one of two ways. The way with which we're most concerned today is from proposals that are made during a public consultation on what we call a program of law reform, which we run every 3 to 4 years. And this conference is part of the public consultation on our 14th program of law reform. The public consultation closed at the end of July, but the projects that are being discussed at this conference have all been submitted as part of that public consultation. So we will be examining all of these potential projects as part of the analysis that we're undertaking of the responses, and the sort of first step in that analysis will be to work up a long list of projects, potential projects, which will then eventually refine into a short list, and then finally agree a program with government. The Lord Chancellor will agree the program on behalf of the government, which will happen, we think, next year. In terms of the conference, we're very pleased to be working with the Criminal Law Reform Now Network. As John mentioned, this is the second such conference on consecutive program consultations. I should just mention that I'm joining from Toronto, so sadly I will miss the morning sessions next week, but members of the criminal law team are also attending today and indeed on Monday and Tuesday of next week. So we will ensure that we have heard not only the papers, but the discussion that follows, and we'll be considering all of that when we analyze the potential programs and work up our long list. The second way in which projects are agreed is via a reference from a government department. And those indeed come along quite regularly, at least in the criminal law sphere, and are, I think, an important way of ensuring that when government has a pressing priority, they can seek law commission expertise on it. Otherwise, if we were sort of limited to our programs, we would really only be canvassing the possibilities every 3 to 4 years, and that clearly wouldn't be a particularly efficient way of using our scarce resources. I thought I'd just close by giving you a flavor of what we have been working on, what we are working on, and what we know we will be working on. So many of you will know that the Sentencing Code, a project which pretty much finished before I arrived at the beginning of last year, but was making its tortuous way through Parliament last year, has now been implemented. And that was a codification project which is one of the things that we do, although not incredibly frequently. I'm sure most of you will have heard that one of the recommendations in our public nuisance report is currently before Parliament, because there's been a lot of discussion about the codification of public nuisance, which was something that we recommended in our report, and that is still in Parliament in as a clause 59 of the police crime sentencing and courts bill. The protection of official data project, the review of the Official Secrets Acts, the Home Office has announced that will be partially implemented as part of work that they're undertaking on espionage and countering hostile state activity. Search warrants is a project which we wrapped up last year, and we're currently awaiting a response from the Home Office. And misconduct in public office, a previous program project, also reported last year. Earlier this year, we published our final report on modernizing communications offenses, and we await to see whether it's like to implement that possibly through the online safety bill, which, as I'm sure you're aware, is currently in draft form. And then in terms of projects that we're currently working on, confiscation of the proceeds of crime will report in the first half of next year and will be accompanied by a draft bill. Hate crime, we intend to report on that in the autumn of this year, so relatively soon. The taking, making, and sharing of intimate images without consent will report in the first half of next year. And corporate criminal liability, we're currently working on an options paper, the consultation period for which closed earlier this week. Finally, you'll have noted possibly that the government's announced that they've asked us to take on 2 other projects, although we're still working on terms of reference for these. One is a project on the way in which evidence is used in prosecutions of serious sexual offences, which comes out of the government's end-to-end rape review. And the other is a review of the law of contempt, which builds on earlier work that the Law Commission has done on contempt, which again came out of an earlier program project. I'll stop there and just say once again that we're really pleased to be collaborating with the CLR and N on this conference, and we look forward to hearing all of the papers and discussing the proposals for projects in due course. Thank you very much for having me.